Come to order. We'll have plenty of time to deal with the evidence once we get through. Let's go ahead and get the charge in. Let's all rise for the jury.
All rise for the jury.
Where's Mr.
Who we look for?
Mr. Goff?
Oh yeah, it's over here.
All right, let's have bring the jury in. Ladies and gentlemen, the jury, now is the time that the court will instruct you as to the law as I find it applicable in this case. I want to state at the beginning that if I say word defendant, that during my charge is referring to both defendants in this case, okay? If I say him or her, I'm not referring to anyone particular, just in that sense. You're considering the case, the state of Georgia versus D. Marquise Kareem Elkins and Karima Elkins. The grand jury of Glenn County indicted defendants in a 14-count indictment. The indictment charges defendant D. Marquise Kareem Elkins with the offenses of malice murder, 2 counts of felony murder, 4 counts of aggravated assault, 2 counts of criminal attempt to commit armed robbery, cruelty to children in the first degree, possession of firearm during the commission of a felony. The indictment charges defendant Karima Elkins with making a false statement and tampering evidence. The indictment reads substantially as follows, and you will have the indictment out with you. State of Georgia versus D. Marquise Elkins and Karima Elkins. The grand jurors selected, chosen, and sworn for the county of Glenn, to wit, and 19 grand jurors in the name, count 1, in the name and behalf of the citizen of Georgia, charged and accused D. Marquise Kareem Elkins with the offense of malice murder for that said accused on or about the 21st day of March 2013 in the county aforesaid did unlawfully with malice aforethought cause to death of Antonio Santiago, a human being, by shooting said victim in the face, all of said act being contrary to the laws of said state, good order, peace, and dignity thereof. Count 2, and the grand jurors aforesaid on the oath aforesaid in the name and behalf of the citizens of Georgia, further charged and accused D. Marquise Kareem Elkins and Dominique Demetrius Lying with the offense of felony murder for the said accused on or about the 21st day of March 2013 in the county aforesaid while in the commission of a felony, to wit, aggravated assault, as alleged in count 4 of this indictment, did cause the death of Antonio Santiago, a human being, all of said act being contrary to the laws of said state, the good order, peace, and dignity thereof. Count 3, and the grand jurors aforesaid on their oaths aforesaid in the name and behalf of the citizens of Georgia, further charged and accused D. Marquise Kareem Elkins and Dominique Demetrius Lying with the offense of felony murder for that the said accused on or about the 21st day, March 2013, in the county aforesaid while in the commission of a felony, to wit, criminal attempt to commit armed robbery, as alleged in count 5 of this indictment, did cause the death of Antonio Santiago, a human being, all of said act being contrary to the laws of the said state, the good order, peace, and dignity thereof. Count 4. And the grand jurors aforesaid on their oaths aforesaid in the name and behalf of the citizens of Georgia, further charged and accused D. Marquise Kareem Elkins and Dominique Demetrius Lying with the offense of aggravated assault for the said accused on or about the 21st day of March 2013 in the county aforesaid did make an assault upon the person of Antonio Santiago with a deadly weapon, to wit, a .22 caliber revolver, a firearm, by shooting said victim in the face, all of said act being contrary to the laws of said state, good order, peace, and dignity thereof. Count 5, and the grand jurors aforesaid on their oaths aforesaid in the name and behalf of the citizens of Georgia, further charged and accused D. Marquise Kareem Elkins and Dominique Demetrius Lying with the offense of criminal attempt to commit armed robbery, a felony, for that said accused on or about the 21st day of March 2013 in the county aforesaid with the intent to commit a theft, did knowingly and intentionally attempt to commit an armed robbery, a felony, and that said accused did point a firearm at Sherry West and demand money, said act constituting a substantial step toward the commission of armed robbery, all said act being contrary to the laws of said state, good order, peace, and dignity thereof. Count 6, in the grand jurors aforesaid on the oaths aforesaid in the name and behalf of the citizens of Georgia, further charged and accused DeMarquise Kareem Elkins and Dominique Demetrius Lang with the offense of aggravated assault for that said accused on or about the 21st day of March 2013 in the county aforesaid did make an assault upon the person of Sherry West with a deadly weapon, to wit, a .22 caliber revolver, a firearm, by shooting said victim in the leg, all said at being contrary to the laws of said state, good order, peace, and dignity thereof. Count 7, in the grand jurors aforesaid on their oaths aforesaid in the name and behalf of the citizens of Georgia, further charged and accused DeMarquise Kareem Elkins and Dominique Demetrius Lang with the offense of aggravated assault for the said accused on or about the 21st day of March 2013 in the county aforesaid did make an assault upon the person of Sherry West with a deadly weapon, to wit, a .22 caliber revolver, a firearm, by striking said victim in the head with said firearm, all said act being contrary to the laws of said state, good order, peace, and dignity thereof. Count 8, in the grand jurors aforesaid on the oaths aforesaid in the name and behalf of the citizens of Georgia, further charged and accused DeMarquise Kareem Elkins and Dominique Demetrius Lang with the offense of cruelty to children in the first degree for that said accused on or about the 21st day of March 2013 in the county aforesaid did maliciously cause Antonio Santiago, a child under the age of 18 years, cruel and excessive physical pain by shooting said victim in the face. All said act being contrary to the laws of said state, good order, peace, and dignity thereof. Count 9, and the grand jurors aforesaid on their oaths aforesaid in the name and behalf of the citizens of Georgia, further charged and accused DeMarquise Kareem Elkins with the offense of possession of a firearm during the commission of a felony for that said accused on or about the 21st day of March 2013 in the county aforesaid did unlawfully have on his person a firearm, to wit, a .22 caliber revolver during the commission of a felony involving the person of another, to wit, criminal attempt to commit armed robbery as alleged in count 5 of this indictment, all said act being contrary to the laws of said state, the good order, peace, and dignity thereof. Count 11 of the indictment, and the grand jurors aforesaid on their oaths aforesaid in the name and behalf of the citizens of Georgia, further charged and accused Kareem Elkins with the offense of making a false statement for that said accused on or about the 22nd day of March 2013 in the county aforesaid, knowingly and willfully make a false statement to officers Stephanie Oliver and Corey Sasser of the Glenn County Police Department in the matter of the investigation into the death of Antonio Santiago, a matter within the jurisdiction of the Glenn County Department and Agency of Glenn County, Georgia, to wit, said accused did provide a false alibi for DeMarquise Elkins when she reported to law enforcement that Elkins was with her during the time of the shooting death of Antonio Santiago, all said act being contrary to the laws of said state, the good order, peace, and dignity thereof. Count 12, and the grand jurors aforesaid on their oaths aforesaid in the name and behalf of the citizens of Georgia, further charged and accused Karima Elkins and Sabrina Elkins with the offense of tampering with evidence for the said accused between the 21st day of March 2013 and the 25th day of March 2013, the exact date of the offense being unknown to the grand jury, in the county aforesaid did knowingly conceal physical evidence, to wit, a .22 caliber revolver used in the shooting death of Antonio Santiago by throwing said firearm into a saltwater pond with the intent to obstruct the prosecution of another person, to wit, DeMarquise Elkins, for the crime of murder, a felony. All said act being contrary to the laws of said state, the good order, peace, and dignity thereof. Count 14, and the grand jurors aforesaid on their oaths aforesaid in the name and behalf of the citizens of Georgia, further charged and accused DeMarquise Kareem Elkins with the offense of criminal attempt to commit armed robbery, a felony, for that said accused on or about the 11th day of March 2013 in the county aforesaid with the intent to commit a theft, did knowingly and intentionally attempt to commit an armed robbery, a felony, and that said accused did point a firearm at Wilfredo Calix Flores and demand his wallet and cell phone, said act constituting a substantial step toward the commission of armed robbery, all said act being contrary to the laws of said state, the good order, peace, and dignity thereof. Count 15, and the grand jurors aforesaid on their oaths aforesaid in the name and behalf of the citizens of Georgia, further charged and accused DeMarquise Kareem Elkins with the offense of aggravated assault for that said accused on or about the 11th day of March 2013, in the county aforesaid, did make an assault upon the person of Wilfredo Calix Flores with a deadly weapon, to wit, a .22 caliber revolver, a firearm, by shooting said victim in the arm with said firearm, all said act being contrary to this state, the good order, peace, and dignity thereof. Ladies and gentlemen, the defendants have entered pleas of not guilty to this indictment. The indictment and the plea forms the issues you are to decide. Neither the indictment nor the pleas of not guilty should be considered by you as evidence. A defendant is presumed innocent until proven guilty. A defendant enters upon the trial of his or her case with a presumption of innocence in his or her favor. This presumption remains with him or her until it is overcome by the state with evidence which is sufficient to convince you beyond a reasonable doubt that he or she is guilty of the offense or offenses charged. No person shall be convicted of any crime unless and until each element of the crime charged is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime or crimes charged beyond a reasonable doubt. There is no burden of proof upon a defendant whatsoever, and the burden never shifts to a defendant to introduce evidence or to prove innocence. When a defense is raised by the evidence, the burden is on the state to negate or disprove it beyond a reasonable doubt. However, the state is not required to prove guilt of a defendant beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from a consideration of the evidence or a lack of evidence or a conflict in the evidence. After giving consideration to all the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied as to any defendant, then that is a doubt of the law, and you should acquit that defendant. But if that doubt does not exist in your minds as to the guilt of any defendant, then you would be authorized to convict any such defendant. If the state fails to prove a defendant's guilt beyond a reasonable doubt, it would be your duty to acquit that defendant. Facts and circumstances that merely place upon a defendant a grave suspicion of a crime charged or merely raise a speculation or conjecture of his or her guilt are not sufficient to authorize the conviction of that defendant. Members of the jury, as I told you, it is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all the evidence presented. Then you must apply the law that I give you in these instructions to the facts as you find them to be. Your oath requires that you will decide this case based upon the evidence. Evidence is the means by which any fact that is put into issue is established or disproved. Evidence includes all the testimony of the witnesses or the equivalent, such as depositions, any exhibits admitted during the trial, any stipulations of the attorneys, that is, any facts to which the attorneys have agreed with approval by the court. Evidence does not include the indictment, the plea of not guilty, opening and closing remarks of attorneys, or questions asked by the attorneys. The parties have entered into stipulations about certain facts, testimony, exhibits. Those stipulations have been approved by the court. Where parties stipulate facts, this is in the nature of evidence. You may take that fact or those facts as given without the necessity of further proof. However, you are not required to do so, and even such matters may be contradicted by other evidence. You shall make all decisions based upon the evidence in this case. Where parties stipulate as to testimony, documents, and or exhibits only, this is in the nature of evidence. You may take that testimony as if it were given in court, and you may rely on it if you find it credible. However, either party may dispute such evidence by other evidence. You must make all decisions based on the evidence in this case. Evidence can be either direct or circumstantial or both. In considering evidence, you may use reasoning and common sense to make deductions and reach conclusions. You should not be concerned about whether evidence is direct or circumstantial. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is proof of a set of facts and circumstances that tend to prove or disapprove another fact by inference, that is, by consistency with such fact or elimination of other facts. There is no legal difference in the weight you may give to either direct or circumstantial evidence. To authorize a conviction on circumstantial evidence, the proved facts must not only be consistent with the theory of guilt, but must exclude every other reasonable theory other than the guilt of the accused. You would be authorized to convict only if the evidence, whether direct or circumstantial or both, excludes all reasonable theories of innocence and proves the guilt of the accused beyond a reasonable doubt. The jury must determine the credibility of witnesses. In deciding this, you may consider all the facts and circumstances of the case, including the witness's manner of testifying, their intelligence, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess a knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. In determining the credibility of witnesses and any testimony by them in court, you may consider, where applicable, evidence offered to attack the credibility or believability of such witness. This would include proof that a witness has been convicted of a felony or offense, or that witness has been convicted of a crime involving dishonesty or false statement. You have received in evidence prior convictions of certain witnesses. You may consider this evidence only insofar as it may relate to the attacking the credibility of those witnesses and not for any other purpose. To impeach a witness is to show that that witness is unworthy of belief. Any witness may be impeached by disproving the facts to which the witness testified. You may determine whether there was evidence that a witness testified falsely about an important fact during the course of the trial as opposed to some other time during the trial. In doing so, you may make a determination whether the misstatement was because of an innocent lapse in memory or an intentional attempt to deceive. You should consider all the facts and circumstances of any prior statements. In assessing the credibility of a witness, you may consider any possible motive in testifying if shown. In that regard, you are authorized to consider any possible pending prosecutions, promises of leniency, or similar matters. You alone decide the believability of witnesses. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided that you find the evidence to be sufficient. An exception to this rule is made in the case of a crime where the witness is an accomplice. The testimony of accomplice alone is not sufficient to warrant a conviction. The accomplice's testimony must be supported by other evidence of some type, and that evidence must be such as would lead to the influence of the guilt of the accused, independent of the testimony of the accomplice. It is not required that supporting evidence be sufficient to warrant a conviction, or that the testimony of the accomplice be supported in every material particular. The supporting evidence must be more than that a crime was actually committed by someone. It must be sufficient to connect the accused with the criminal act, and must be more than sufficient to merely cast upon the accused a grave suspicion of guilt. Slight evidence from another source that connects the accused with the commission of the alleged crime and tends to show participation in it may be sufficient supporting evidence of the testimony of accomplice. In order to convict, that evidence, when considered with all the other evidence in the case, must be sufficient to satisfy you beyond a reasonable doubt that the accused is guilty. The sufficiency of supporting evidence of an accomplice is a matter solely for you, the jury, to determine. Any out-of-court statement made by one of the defendants on trial, in this case after the alleged criminal act has ended, may be considered only against the person who made the statement, and only if you find such statement was freely and voluntarily made. If you find an out-of-court statement was made to the police freely and voluntarily by a defendant on trial in this case, then you are to consider the statement only as if against the particular defendant who made it. A defendant does not have to present any evidence or testify. If a defendant chooses not to testify, you may not consider that in any way in making your decision. A statement that a defendant allegedly made has been offered for your consideration. Before you Before you may consider this as evidence for any purpose, you must determine whether the defendant's statement was voluntary and if the statement was given in custody, whether the defendant was properly advised of his or her constitutional rights. To be voluntary, a statement must be freely and willingly given without coercion, duress, threats, use of violence, fear of injury, or any suggestions, promises of leniency or reward. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be a product of a free will and not under compulsion or any necessity imposed by others. In determining voluntariness, you may also consider what to extent the defendant was informed of his or her rights, as I will explain in a moment. You may consider the duration and conditions of the detention as factors relevant to the question of whether or not a statement was freely and voluntarily made. However, under the law, in order for a statement to be excluded because of illegal detention, it must be shown that the statement was in fact induced by some illegal detention. The burden of proof is on the state to establish that the statement was voluntary, that is, freely and voluntarily made. If you do not find that a statement was voluntary, you may not consider it for any purpose. If you find that the statement was made while in custody and as a result of police questioning, you must also determine whether the defendant was advised of his or her constitutional rights and whether the defendant clearly understood and knowingly gave up such rights. The constitutional rights that law enforcement officers must explain that the defendant must understand and voluntarily give up before any custodial statement is taken by law enforcement are as follows. 1, the defendant had the right to remain silent. 2, if the defendant chose not to remain silent, anything he or she said could be used as evidence against the defendant in court. 3, the defendant had a right to consult a lawyer before any questioning and to have the lawyer present with him or her at all times during any questions. And 4, if the defendant did not have money for a lawyer would have been provided for him or her to represent him or her before any questioning and to present with him or her during any questioning. If the defendant exercises any of these rights, such as requesting an attorney, the police cannot question the defendant any further without an attorney being present. If the police initiate or continue conversation with the defendant after the defendant exercises such right, then any statement made to the police by the defendant after he or she exercises such right would not be voluntary, and you must disregard it entirely and completely in reaching your verdict in the case, except for the purpose of attacking witness credibility. However, if the defendant solely on his or her own initiative, after exercising such right, freely and voluntarily requests and initiates further conversation with the police without an attorney and without any request, instigation, coercion, duress, fear, or hope of benefit or reward or other action on the part of the police, then you would be authorized to consider it, provided you find from the evidence in the court's instructions that any such conversation or statement was otherwise freely and voluntarily given by the defendant. The burden of proof is upon the state to establish that the warnings of all rights mentioned were given and they were understood and only given up by the defendant. If you find that the defendant's statement was voluntary and that all the warnings as to the defendant's constitutional rights were given, that the defendant did understand the meaning of what was said and only gave up such rights, then you may consider it as evidence. If so, then you must apply the general rules for testing the believability of witnesses and decide what weight, if any, you will give to all or any part of such evidence. If you fail to find the defendant was properly informed of these rights and that he or she understood and gave up those rights, you must disregard the statement entirely and give no consideration to it in reaching your verdict, except for the purpose of attacking the credibility of the witness. You should consider with great care and caution the evidence of any out-of-court statement made allegedly by a defendant offered by the state. The jury may believe such statement in whole or in part, believing that which you find to be true and rejecting that which you find to be untrue. You alone have the duty to apply the general rules for testing the believability of witnesses and to decide what weight should be given to all or any part of such evidence. A defendant's out-of-court statement, unsupported by any other evidence, even if believed, is not sufficient to justify conviction. However, proof by other evidence beyond reasonable doubt that the crime alleged has been committed may constitute supporting evidence of the defendant's statement, if any, should you so find. The law does not fix the amount of supporting evidence necessary. You must determine whether or not other evidence sufficiently supports a defendant's statement so as to justify a conviction. If you find that there was a statement made by the defendant that was supported by other evidence, the degree of proof necessary to convict is that you be satisfied of the guilt of the defendant beyond any reasonable doubt. Identity is a question of fact for you to determine. Your determination of identity is dependent upon the credibility of the witness or witnesses offered for this purpose. You should consider all the factors previously charged regarding the credibility of witnesses. Some, but not all, the factors you may consider in assessing the reliability of identification are: 1, the opportunity of the witness to view the alleged perpetrator at the time of the alleged incident; 2, the witness' degree of attention toward the alleged perpetrator at the time of the alleged incident; 3, the possibility of mistaken identity; 4, whether the witness identification may have been influenced by factors other than the view that the witness claimed to have; 5, whether the witness on any prior occasion did not identify the defendant in this case as the alleged perpetrator; and 6, the length of time between the crime and the out-of-court identification. It is for you to say whether, under the evidence in this case, the testimony of the witnesses and the facts and circumstances of the case sufficiently identify a defendant beyond a reasonable doubt as the perpetrator of the alleged crime or crimes. It is not necessary that the defendant show that another person committed the alleged offense or offenses. If you do not believe that a defendant has been sufficiently identified as the person who committed the alleged crime or crimes, or if you have any reasonable doubt as such, then it would be your duty to acquit that defendant. The burden of proof rests on the state to prove beyond a reasonable doubt the identity of each defendant as the person who committed the crime or crimes alleged in this bill of indictment. Ladies and gentlemen, defendants are charged with crimes against the laws of the state. A crime is a violation of a statute in this state in which there is a joint operation of an act and an intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be, in your discretion, inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a penal statute, but means simply the intention to commit the act that is prohibited by a statute. A defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, or other circumstances connected with the act for which he or she is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. You may infer, if you wish to do so, that the acts of a person of a sound mind and discretion are the product of that person's will, and that a person of sound mind and discretion intends the natural and probable consequences of those acts. Whether or not you make any such inferences is matter solely with your discretion. Every party to a crime may be charged with and convicted of commission of the crime. A person is a party to the crime only if that person directly commits the crime, 1. 2, intentionally helps in the commission of the crime, 3, intentionally advises, encourages, hires, counsels, or procures another to commit the crime, or 4, intentionally causes some other person to commit the crime under such circumstances that the other person is not guilty of any crime either in fact or because of legal incapacity. Any party to the crime who did not directly commit the crime may be prosecuted for the commission of the crime upon proof that the crime was committed and that the person was a party to it, even though the person alleged to have directly committed the crime has not been prosecuted or convicted, has been convicted of a different crime or a degree of crime, is not amenable to justice, or has been acquitted. Knowledge on part of a defendant that a crime has been committed Knowledge on the part of a defendant that a crime was being committed and that the defendant knowingly and intentionally participated in or helped in the commission of such crime must be proved by the state beyond a reasonable doubt. If you find from the evidence in this case that the defendant had no knowledge that a crime was being committed, or that the defendant did not knowingly, intentionally commit, participate, or help in the commission of the alleged offense, then it would be your duty to acquit that defendant. On the other hand, should you find beyond a reasonable doubt that the defendant had knowledge that a crime was being committed and he or she knowingly, intentionally participated or helped in the commission of it, then you would be authorized to convict that defendant. A jury is not authorized to find a person who was merely present at the scene of the commission of a crime at the time of its perpetration guilty of consent in or concurrence in the commission of the crime unless evidence shows beyond a reasonable doubt that such person committed the alleged crime, helped in the actual preparation of crime, or participated in the criminal endeavor. A jury is not authorized to find that a person who was merely associated with other persons involved in the commission of a crime guilty of consent in or concurrence in the commission of the crime unless the evidence shows beyond a reasonable doubt that such person helped in the actual perpetration of the crime or participated in the criminal endeavor. The law requires that criminal action shall be indicted in the county in which the crime was committed, except as otherwise provided by law. This is called venue. Venue is a jurisdictional fact, and that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any other offense. Venue must be proved by direct or circumstantial evidence or both. The state must prove that venue in this case is proper in Glenn County, and if you find that burden has not been met, it would be your duty to acquit the defendants. The indictment against the defendant DeMarquise Kareem Elkins is stated in 11 counts. In count 1 of the indictment, Mr. Elkins is charged with malice murder. In connection with that count, I instruct you that a person commits murder when that person unlawfully and with malice aforethought, either express or implied, causes the death of another human being. Express malice is that deliberate intention unlawfully to take away the life of another human being, which is shown by external circumstances capable of proof. Malice may but need not be implied when no considerable provocation appears and when all the circumstances of the killing show an abandoned and malignant heart. It is for you to decide whether or not the facts and circumstances of this case show malice. To constitute murder, the homicide must have been committed with malice. Legal malice is not necessarily ill will or hatred, but is the unlawful intention to kill without justification, excuse, or mitigation. If a killing is done with malice, no matter how short a time the malicious intent may have existed, such killing constitutes murder. Georgia law does not require premeditation, and no particular length of time is required for malice to be generated in the mind of a person. It may be formed in a moment, and instantly a mortal wound may be inflicted. Yet, if malice is in the mind of the accused at the time of doing the act or killing and moves the accused to do it, such is sufficient to constitute the homicide as murder. Proof of a particular motive is not essential to constitute the crime of murder. Evidence of motive, if any, is admitted for your determination as to whether or not it establishes the state of the defendant's mind at the time of the alleged homicide. Ladies and gentlemen, after considering the testimony and evidence presented to you together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant, DeMarquise Kareem Elkins in Glenn County, did on or about March 21st, 2013, commit the offense of malice murder as alleged in count 1 of the indictment. You would be authorized to find him guilty as that count. In the event, the form of your verdict would be, we, the jury, find the defendant guilty of malice murder. If you do not believe that Mr. Elkins is guilty of the offense of malice murder, or if you have any reasonable doubt as to his guilt, then it would be your duty to acquit Mr. Elkins as to that count, in which the form of your verdict would be, we, the jury, find the defendant not guilty of malice murder. In counts, and ladies, at the end, we have a verdict form, and I'll go over that verdict form when I finish charging the case. That will go out with the jury. In counts 2 and 3 of this indictment, Mr. Elkins is charged with felony murder. I charge you that a person commits the crime of murder when in the commission of a felony that person causes the death of another human being with or without malice. Under the laws of Georgia, aggravated assault and criminal attempt to commit armed robbery are felonies and are defined as follows. I instruct you that a person commits assault when that person attempts to commit a violent injury to the person of another or commits an act that places another in reasonable apprehension of immediately receiving a violent injury. A person commits the offense of aggravated assault when that person assaults another with a deadly weapon. To constitute an aggravated assault, actual injury to the alleged victim need not be shown. It is only necessary that the evidence show beyond a reasonable doubt that the defendant attempted to cause a violent injury to the alleged victim or intentionally committed an act that placed the alleged victim in reasonable fear of immediately receiving a violent injury. The state must also prove as a material element aggravated assault, as alleged in this case, that the assault was made with a deadly weapon. A firearm, when used as such, is a deadly weapon as a matter of law. A person commits criminal attempt to commit armed robbery when, with the intent to commit armed robbery, the person performs any act that constitutes a substantial step toward the commission of the crime of armed robbery. A person commits armed robbery when, with the intent to commit theft, that person takes property of another from a person or the immediate presence of another by use of an offensive weapon or by any replica, article, or device having the appearance of such weapon. An offensive weapon is any object, device, or instrument that, when used offensively against a person, is likely to or actually does result in the death or serious bodily injury. The character of a weapon may be established by direct or circumstantial evidence. If you find and believe beyond a reasonable doubt that Mr. Elkins committed the homicide alleged in this bill indictment at the time he was engaged in the commission of a felony of aggravated assault and or criminal attempt to commit armed robbery, then you would be authorized to find Mr. Elkins guilty of murder, whether the homicide was intended or not. I have already defined both aggravated assault and criminal attempt to commit armed robbery for you. In order for a homicide to have been done in the commission of either of these felonies, there must be some connection between the felony and the homicide. The homicide must have been done in carrying out the unlawful act and not collateral to it. It is not enough that the homicide occurred soon or presently after the felony was attempted or committed. There must be some legal relationship between the homicide and the felony so as to cause you to find that the homicide occurred before the felony was at an end or before any attempt to avoid conviction or arrest for the felony. The felony must have a legal relationship to the homicide to be at least concurrent with it in part and be part of it in an actual and material sense. A homicide is committed in the carrying out of a felony when it is committed by the accused while engaged in the performance of any act required for the full execution of the felony. Ladies and gentlemen, after considering the testimony and evidence presented to you together with the charge of the court, you should find and believe beyond a reasonable doubt that defendant DeMarquise Kareem Elkins in Glenn County, Georgia, did on or about March 21, 2013, commit the offense of felony murder as alleged in count 2 of the indictment. You would be authorized to find him guilty as to that count. In that event, the form of your verdict would be, we, the jury, find the defendant guilty of felony murder. If you do not believe that Mr. Elkins is guilty of the offense of felony murder, or if you have a reasonable doubt as to his guilt, then it would be your duty to acquit Mr. Elkins as to that count, in which event the form of your verdict would be, we, the jury, find the defendant not guilty of felony murder. If after considering the testimony and evidence presented to you together with the charge of the court, you should find and believe beyond a reasonable doubt the defendant DeMarquise Kareem Elkins in Glenn County, Georgia, did on or about March 21, 2013, commit the offense of felony murder as alleged in count 3 of the indictment, you would be authorized to find him guilty of that count. In the event your form of your verdict would be, we, the jury, find the defendant guilty of felony murder. If you do not believe that Mr. Elkins is guilty of the offense of felony murder, or duty to acquit Mr. Elkins as to that count, in which the form of your verdict would be, we, the jury, find the defendant not guilty of felony murder. In counts 4, 6, 7, and 15 of the indictment, Mr. Elkins is charged with aggravated assault with a deadly weapon, which the court has previously defined for you. Ladies and gentlemen, if after considering the testimony and evidence presented to you together with the charge of court, you should find and believe beyond a reasonable doubt that defendant DeMarquise Kareem Elkins in Glenn County did on or about March 21st commit the offense of aggravated assault with a deadly weapon upon the person of Antonio Santiago as alleged in count 4 of the indictment, you would be authorized to find Mr. Elkins guilty as that count. In the event your form of verdict would be, we, the jury, find the defendant guilty of aggravated assault. If you do not believe that Mr. Elkins is guilty of the offense of aggravated assault upon Antonio Santiago as alleged in count 4 of the indictment, or if you have any reasonable doubt as to his guilt, then it would be your duty to acquit Mr. Elkins as to that count, in which event the form of your verdict would be, we, the jury, find the defendant not guilty of aggravated assault. If after considering the testimony and evidence presented to you together with the charge of court, you should find and believe beyond a reasonable doubt that defendant DeMarquise Kareem Elkins in Glenn County, Georgia, did on or about March 21st, 2013, commit the offense of aggravated assault upon Sherry West as alleged in count 6 of the indictment, you would be authorized to find Mr. Elkins guilty as to that count. In the event your form of your verdict would be, we the jury find the defendant guilty of aggravated assault. If you do not believe that Mr. Elkins is guilty of the offense of aggravated assault upon Sherry West as alleged in count 6 of the indictment, or if you have any reasonable doubt as to his guilt, then it will be your duty to acquit Mr. Elkins as to that count, in which event the form of your verdict would be, we the jury find the defendant not guilty of aggravated assault. If after considering the testimony and evidence presented to you together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant DeMarquise Kareem Elkins in Glenn County, Georgia did on or about March 21st, 2013 commit the offense of aggravated assault upon Sherry West as alleged in count 7 of the indictment, you would be authorized to find Mr. Elkins guilty as to that count. In the event your form of your verdict would be, we the jury find the defendant guilty of aggravated assault. If you do not believe that Mr. Elkins is guilty of the offense of aggravated assault upon Sherry West as alleged in the count 7 of the indictment, or if you have a reasonable doubt as to his guilt, then it will be your duty to acquit Mr. Elkins as to that count, in which event the form of your verdict would be, we the jury find the defendant not guilty of aggravated assault. If after considering the testimony and evidence presented to you together with the charge of court, you should find and believe beyond a reasonable doubt that the defendant DeMarquise Kareem Elkins in Glenn County, Georgia did on or about March 11, 2013 commit the offense of aggravated assault upon Wilfredo Calix Flores as alleged in count 15 of the indictment, you'd be authorized to find Mr. Elkins guilty as to that count. In that event, the form of your verdict would be, we the jury find the defendant guilty of aggravated assault. If you do not believe that Mr. Elkins is guilty of the offense of aggravated assault upon Wilfredo Calix Flores as alleged in count 15 of the indictment, or if you have any reasonable doubt as to his guilt, then it would be your duty to acquit Mr. Elkins as to that count, in which event the form of your verdict would be, we the jury find the defendant not guilty of aggravated assault. As to counts 5 and 14 of the indictment, Mr. Elkins is charged with criminal attempt to commit armed robbery, which I have already defined that for you. If after considering the testimony and evidence presented to you together with the charge of the court, you should find and believe beyond a reasonable doubt the defendant DeMarquise Kareem Elkins in Glenn County, Georgia did on or about March 21st, 2013 commit the offense of criminal attempt to commit armed robbery upon Sherry West as alleged in count 5 of the indictment, you would be authorized to find Mr. Elkins guilty as to that count. In the event the form of your verdict would be, we the jury find the defendant guilty of criminal attempt to commit armed robbery. If you do not believe that Mr. Elkins is guilty of the offense of criminal attempt to commit armed robbery upon Sherry West as alleged in count 5 of the indictment, or if you have any reasonable doubt as to his guilt, then it would be your duty to acquit Mr. Elkins as to that count, in which event the form of your verdict would be, we the jury find the defendant not guilty of criminal attempt to commit armed robbery. If after considering testimony and evidence presented to you together with the charge of the court, you should find and believe beyond a reasonable doubt the defendant DeMarquise Kareem Elkins in Glenn County, Georgia did on or about March 11, 2013 commit the offense of criminal attempt to commit armed robbery upon Wilfredo Calix Flores as alleged in count 14 of the indictment, you will be authorized to find Mr. Elkins guilty as to that count. In the event the form of your verdict would be, we the jury find the defendant guilty of criminal attempt to commit armed robbery. If you do not believe that Mr. Elkins is guilty of the offense of criminal attempt to commit armed robbery upon Wilfredo Calix Flores as alleged in count 14 in the indictment, or if you have any reasonable doubt as to his guilt, then it would be your duty to acquit Mr. Elkins as to that count. In which event the form of your verdict would be, we the jury find the defendant not guilty of criminal attempt to commit murder. In count 8 of the indictment, Mr. Elkins is charged with cruelty to children in the first degree. Any person who commits the offense of cruelty to children when that person maliciously causes a child under the age of 18 cruel or excessive physical or mental pain. Malice is not ill will or hatred. For the purposes of this crime, malice means an actual intent to cause the particular harm produced, that is, physical pain without justification or excuse. Malice is also the wanton and willful doing of an act with an awareness of a plain and strong likelihood that such particular harm may result. Intention may be shown by the circumstances connected with the offense. If after considering the testimony and evidence presented to you together with the charge of this court, you should find and believe beyond a reasonable doubt that defendant DeMarquise Elkins in Glenn County, Georgia did on or about March 21, 2013 commit the offense of cruelty to children in the first degree as alleged in count 8 of the indictment, you would be authorized to find Mr. Elkins guilty as to that count. In that event, the form of your verdict would be, we the jury find the defendant guilty of cruelty to children in the first degree. If you do not believe that Mr. Elkins is guilty of the offense of cruelty to children in the first degree as alleged in count 8 of the indictment, or if you have any reasonable doubt as to his guilt, then it would be your duty to acquit Mr. Elkins as to that count, in which event the form of your verdict would be, we the jury find the defendant not guilty of cruelty to children in the first degree. In count 9 of the indictment, Mr. Elkins is charged with possession of firearm during the commission of a felony. A person commits the offense of possession of firearm during the commission of a felony when the person has own or within arm's reach of his person a firearm during the commission of any attempt to commit a felony, which is a crime against or involving the person of another. The offense of criminal attempt to commit armed robbery is a felony in the laws of this state and has previously been defined for you. If after considering the testimony of evidence presented to you together with the charge of the court, you should find and believe beyond a reasonable doubt that defendant DeMarquise Elkins in Glenn County, Georgia, did, on or about March 21st, 2013, commit the offense of possession of firearm during the commission of a felony, as alleged in count 9 of the indictment, you would be authorized to find Mr. Elkins guilty as that count. In that event, your form of the verdict would be, we the jury find the defendant guilty of possession of firearm during the commission of a felony. If you do not believe that Mr. Elkins is guilty of possession of firearm during the commission of a felony as alleged in count 9 of the indictment, or if you have any reasonable doubt as to his guilt, then it would be your duty to acquit Mr. Elkins as to that count, in which event the form of your verdict would be, we the jury find the defendant not guilty of possession of firearm during the commission of a felony. The indictment against defendant Karima Elkins is stated in 2 counts. In count 11 of the indictment, Ms. Elkins is charged with making a false statement. A person makes a false statement when he or she knowingly and willfully falsifies, conceals, or covers up by any trick, scheme, or device a material fact or makes a false, fictitious, or fraudulent statement or entry in any manner within the jurisdiction of any department or agency of state government or of the government of any county, city, or other political subdivision of the state. If after considering the testimony evidence presented to you together with the charge of the court, you should find and believe beyond a reasonable doubt that defendant Karima Elkins in Glenn County did, on or about March 22nd, 2013, commit the offense of making a false statement as alleged in count 11 in the indictment, you'd be authorized to find Ms. Elkins guilty as to that count. In that event, the form of your verdict would be, we the jury find the defendant guilty of making a false statement. If you do not believe that Ms. Elkins is guilty of making a false statement as alleged in count 11 of the indictment, or if you have reasonable doubt as to her guilt, then it would be your duty to acquit Ms. Elkins as to that count, in which event the form of your verdict would be, we the jury find the defendant not guilty of making a false statement. In count 12 of the indictment, Ms. Elkins is charged with tampering with evidence. A person commits the offense of tampering with evidence when, with the intent to prevent the apprehension or cause the wrongful apprehension of any person or obstruct the prosecution or defense of any person, he or she knowingly destroys, alters, conceals, or disguises physical evidence or makes, devises, prepares, or plants false evidence. If after considering the testimony evidence presented to you together with the charge of the court, you should find and believe beyond a reasonable doubt that defendant Karima Elkins in Glenn County, Georgia did between the 21st day of March 2013 and the 25th day of March 2013 commit the offense of tampering with evidence as alleged in count 12 of the indictment, you'd be authorized to find Ms. Elkins guilty as to that count. In that event, the form of your verdict would be, we the jury find the defendant guilty of tampering with evidence. If you do not believe that Ms. Elkins is guilty of tampering with evidence as alleged in count 12 of the indictment, or if you have reasonable doubt as to her guilt, then it would be your duty to acquit Ms. Elkins as to that count, in which the event the form of your verdict would be, we the jury find the defendant not guilty of tampering with evidence. Though you may consider all the evidence as a whole, a conviction of one defendant does not necessarily require conviction of another. You, the jury, must determine the guilt or innocence of each defendant separately. Ladies and gentlemen, by no ruling or comment that the court has made during the progress of the trial of this trial, has the court intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of any defendant. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given to you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. In citing this case, you should not be influenced by sympathy or prejudice for or against either party. You are only concerned with whether the state has carried its burden of proving the guilt of the defendants beyond a reasonable doubt. You are not to concern yourself with punishment. One of the first duties in the jury room will be to select one of your number to act as foreperson, who will preside over your deliberations and who will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind, consult with one another, and consider each other's views. Each of you must decide the case for yourself, but you should do so only after discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if you are convinced that is wrong. However, you should not surrender an honest opinion in order to be congenial or to reach a verdict solely because of the opinions of other jurors. If it becomes necessary during your deliberations to communicate with the court, you may send a note to the bailiff signed by your foreperson. No member of the jury should ever attempt to communicate with the court by any means other than a signed writing, and the court will not communicate with any member of the jury on any subject touching the merits of this case other than in a writing or orally here in court. Ladies and gentlemen, whatever your verdict is, it must be unanimous. That is, it's to be agreed to by all 12. The verdict must be signed by one of your members as foreperson, dated, and returned to be published in open court. I'm now going to ask you to retire, but we're going to take it's going to let you have a lunch break, which you'll have your lunch here in the courtroom before you start your deliberations. Before you start, you're not going to be able to start your deliberations until after we send the indictment back and all the evidence, okay? So first thing we're going to do is go to lunch, in which there's 2 alternates. The alternates will eat with you at lunch, so at this time when I put you in recess for lunch, everybody will be together, and then the alternates will be separated from you to begin your deliberations. Very important during lunch, don't discuss this case. You're not allowed to discuss this case amongst yourselves or allow anyone to discuss it with you until you have picked your foreman and you have received the indictment and the evidence in this case. Okay? With those instructions, we'll be in recess for lunch, and then we'll
It's all rise for the jury.
give you further instructions.
Be seated, please.
Mr. McIlvain, any exceptions for the charge of the court? Mr. Lockwood?
I would object to the charge of party to the crime being given, as I noted my exception to yesterday evening. Also, I would object to the lack of the abandonment charge, which I requested yesterday, the lack of the lesser included offense charge as to possession of a firearm by someone under the age of 18 as to count 9, which I requested yesterday, and the juvenile rights, which I requested yesterday with respect to the constitutional rights read to Mr. Elkins.
So noted. Any objections from the state?
No, Your Honor.
Okay, jury, y'all go ahead and let's get the evidence together. You know what, I didn't really talk too much about the verdict form. Have y'all seen the verdict form? I told them I'd send it out with them. I didn't really go over it with them, but I think they heard enough out of 32 pages on how to fill it out. Pardon me? 2 sentences.
He skipped it on purpose, yeah.
I skipped it on purpose.
Yeah. I agreed with the skip.
It's not part of, I'm not sending it out right now.
Can I inquire, is that the courts intend to submit the written charge to the jury so they can have it in the jury room?
Only if they request it. We have it ready if they request it. If they decide they need it, or if they start asking a lot of questions, then maybe we'll send it out. Other than that, I won't send it out. I don't know. Is it is? You sure?
Yes.
Make sure. Look at the verdict form and look at the redacted indictment. I want to put on the record that everybody's looked at that. Make sure everybody agrees with it.
The state has no objection to the The state has no objection to the verdict form or to the redacted indictment that will go into the jury room.
Elkins has no objection to the verdict form or redacted indictment. Or the indictment as redacted.
DeMarquise Elkins has no objection as to the redacted indictment. Let me finish going through the verdict form.
Okay, please. I believe Mr. Lockwood has caught several errors on our verdict form maybe before.
On the verdict form? Oh,
Very detail oriented. That's why I want y'all to look at it.
Speaking of in the past,
oh, in the past. Oh,
I have no objection to the verdict form, Your Honor.
All right, so they'll be ready to go out. Now, let's go ahead and just get all the evidence ready, because then when I'll have the bailiffs will instruct me when they're finished eating lunch. Do y'all wish me to bring them back into the courtroom to separate them out once they've eaten lunch?
you mean separate out, you mean excuse the alternates?
Well, I'm not going to excuse the alternates. We have a separate room.
Well, I'm saying
I have a separate room for those.
take them out of the jury deliberation room.
Right.
Okay.
Right now, they're not even eating in the jury deliberation. They're eating in a...
We have no objection to the alternates being excused outside of, we have no objection to the alternates being excused apart from being in open court, just put in a separate room.
Karima Elkins has no objection. Oh, come on. Karima Elkins has no objection to the court dismissing him in the back or bringing him out, however the court sees fit to do it.
DeMarquise Elkins would leave that to the court's preference, whether it wishes to do it in open court or do it in the back. It makes no
All right,
difference.
thank you. I would like from both Mr. McIlvain, Mr. Lockwood, I'd like from both of y'all at this time to state on the record that we've had numerous sidebars in this case, that y'all have kept your clients informed as to what those sidebars have been. And
We've done that, Your Honor.
okay.
I've explained it to my client each time, Your Honor.
All right, very good.
Jackie, you already see these posters? All right. Just
Well, I have everything that is